Well, I'm happy to be able to do this. And it is sort of exciting what happened with the American Law Institute, but I should perhaps start out by saying this is going to be a long road to solve this problem. So no one thing is going to be the magic pill, but I do think this was an important development. So I better tell you what the American Law Institute even is, because lawyers and especially law professors are well steeped in it, and most folks don't have any reason to know. So it's actually an independent nonprofit organization that's about to celebrate its 100th anniversary. And it was formed back when by a bunch of sort of Eastern worthies, sort of fancy lawyers in the East, in New York and Washington and around there. And the idea at that point was that they would try to improve the law by, and a lot of the law, especially private law, like tort law and contract law and stuff, was really English common law, the American descendant of English common law, which means judge-made law. And so they started out simply, we're going to try to improve the law. There's all these decisions that are hard to sort of figure out. We're going to try to put them all together and have very clear and rational and organized statements of what all the rules are, with lots of commentary to help people figure them out. And this is going to be our contribution to the improvement of the law. That's where they started 100 years ago. And they gradually developed a very important role in American law. And their ambition and their projects grew. They did more projects on more subjects, and they have become a real force. They're very frequently cited by courts. There's a lot of areas of law that have been very heavily influenced by these what were classically called restatements of the law that were done by the American Law Institute. And one of the things about the organization that makes it rather unique is that it combines practicing lawyers and legal scholars and judges. They're all members of the American Law Institute. You become a member, you need to be nominated. It's and voted in. It's not that heavy a bar, but there is some process. And then there's a council of the American Law Institute, which is kind of like the board of directors. It has about 40 people on it, and they're all extremely distinguished people. They're judges on state Supreme Courts, as a judge in the California Supreme Court, federal judges, people who've gone, who've served as, major officers in governmental positions, attorneys general and whatever. And, a lot of partners in major law firms and legal scholars. And so it has a kind of a status historically. And so while it has no official role, it can't make the law. Courts tend to pay attention to what it says. Okay. In 1962, they took on what was for them a somewhat different sort of enterprise, because it was statutory, and they prepared something called the Model Penal Code. And the Model Penal Code was just as it sounds. It was a penal code. A state could just adopt it as its penal code and replace the laws that were there. And it was motivated by the same sorts of concerns initially that motivated the other projects. The criminal law it sort of grew up in pieces and here and there, and a lot of confusing concepts that really would be improved with some clarification. And so they undertook this project in 1962. And it turned out to be one of their very influential projects. So about half the states adopted the model penal code either entirely or in large portions of it. And even in the remaining states, if they didn't adopt them, they nonetheless, the courts would refer to provisions of the model penal code or commentary in interpreting their own criminal statutes. And, when you do something like the model penal code, you've got to make rules about things that are potentially contentious. There's no way to avoid it, even if you're not looking to do that. And one of the examples of what was done in the 1962 model penal code was it basically it had no criminal penalties for consensual adult sexual behavior, right? And that was a big change in big parts of the country. So where certainly at that time in many states, it was a crime, homosexual behavior between consenting adults was a crime. And sometimes various sexual acts between a man and a woman were a crime if they weren't traditional forms of sexual acts. I mean, oral sex was a crime in a lot of states, et cetera. So the 1962 model penal code decriminalized all of that. And that actually was very important. It was a very important development, and it did influence the law a lot. And so by the time the Supreme Court decided about 10 years ago that laws criminalizing homosexual acts violated the Constitution, consensual homosexual acts between adults, there weren't very many states that still had such laws. Only a couple. Almost the rest of the country had repealed them. So, and that was, I think, in part, the influence of the model penal code. Okay, so about 10 years ago, the Institute decided that 1962 code would benefit from some updating. And in particular, they were concerned about the article of the code that addressed sexual assault and related offenses. That's the name of the article, sexual assault and related offenses. So they appointed a reporter, and this is their normal route. They appoint somebody, is normally an academic, to be, quote, the reporter. And the reporter really writes all the drafts and has a lot of influence on what happens, but the reporter meets periodically with bodies, members consultative group and an advisory council that are appointed, and they prepare drafts, and those drafts are vetted by these groups, and then there's feedback, and then the reporter revises, et cetera, and then eventually they have a draft, and usually it's just pieces. They don't do the whole thing at once. So there'll be a piece of the project then that's approved by the council. And then when it's approved by the council, it goes to the membership at the annual meeting, which occurs in May, and the members vote on it. And as you can tell by my description of the procedure, this is sort of time consuming. The typical project from beginning to end takes something like 10 years and produces a document that's, many hundreds of pages long, because there's commentary that explains, there's all the research, these are all, we looked at all of the cases, all the statutes, all the relevant social science research, and then so there's that commentary, and then there's what's called the black letter, which are the actual rules that they're proposing that are supported by that commentary. I actually was the reporter for a big project that they did on family dissolution. And it just took over my life for the 10 years of the project. It was very difficult to really do any other sort of research. Any event, so they started this 10 years ago, and the reporter for the project was a fellow named Steve Schulhofer, who was a very distinguished professor of criminal law at New York University, who'd written a lot on sexual offenses and rape law, and that's one of the reasons he was chosen for this. Well, the 1962 model penal code, of course, had no provisions about registries. It couldn't have provision. I mean, there were no registries at that time. The very idea of it hadn't crossed anybody's mind. And so that was one of the things that Steve said at the beginning, that we needed to include a section of the revised article on sexual assaults on the registry. And so I went. I'm a member of the ALI. I went to my first meeting in which that was discussed, which had, in ALI language, was called a preliminary draft. And there's nothing more preliminary in the ALI than a preliminary draft. It's just basically the first thoughts of the reporter, and it's presented. It's not presented to any official body. It's presented to these consultative groups that I mentioned. And I was part of the members' consultative group, and I went to that meeting, and I was really a little bit surprised, but very pleased to see that Steve was taking a very skeptical eye toward the registry, and that the people who attended that meeting, most of them seemed prepared to go along with him. There were a few people who raised questions. And so that meeting, I said, was, I think, about 8 years ago. And in the meanwhile, so this progressed, and it went through a lot. And there were a lot of other fights, I should say, in this project that had nothing to do with the registry. Steve was a big proponent of affirmative consent in rape law, so that you needed, so that was very contentious. There were a lot of disputes about that, and a lot of other things. So this project was one of the projects that generated lots of discussion, went back to the membership a bunch of times after revisions and whatever. And so finally, in 2021, I forget now, 2021, what year are we? Yeah, 2021. There was finally, what's called tentative draft. There's preliminary drafts. Then there's council drafts, which is a draft that's prepared to go to the council. When the council approves it, it becomes a tentative draft, and then it goes to the membership for approval. And finally, in 2021, the council approved a draft that included all of the registry provisions. And it was a breathtakingly wonderful take on the registry. And it went to the membership. And that was during the pandemic era, when they held that membership meeting by Zoom, which it's really something, with a meeting of 400 or so people by Zoom. But any event, so that took place, and it was approved. And I was quite excited, but there were a few small changes, they weren't important, but they had to go back to the council for the council to sign off on a couple of amendments that had been passed by the membership. Well, while in between that meeting and that council meeting, the Department of Justice, the United States Department of Justice, I guess, I don't know if they hadn't been paying attention, or they just didn't believe that the ALI would do what was being proposed. But they wrote a letter to the council saying, you can't approve this, and really arguing vociferously. And then there was a second letter that came to the council prepared by, I forget which attorney general of one state. Anyway, it was signed by the attorneys general of 26 states, also opposing it. Now, they had some objections to other parts, but they were certainly united in their objection to the registry provisions. And then NCMEC, the National Center for Missing and Exploited Children, they also wrote a letter. So you had these three these are really heavyweight things. And basically what they were asking the council to do was to rethink something that the council and the membership had already approved and was just awaiting what was normally an ALI process pro forma final sign off.
What was the big sticking point with them?
Well, okay. They had a number, but I'm going to on some of the other provisions. But on the registry, the thing I think that got them the most, and this was at a memo that Steve Schulhofer, the reporter, wrote in explaining what happened. They objected vociferously, all three groups, to the provisions of the model penal code, the new model penal code, that say that the registry, there's no public access to registry information, none at all. There can't be a website, and there can't be any public notification. There can't be letters to neighbors that somebody's moving in. All of that's abolished. There is still a registry. Steve debated whether there should be a registry at all, but he finally decided that they would have a registry, but exclusively for law enforcement personnel who could access it, not as a general matter, but in the course of investigating a particular crime, if accessing it for that purpose would be helpful in the investigation of a particular crime. And that was that. They objected vociferously to that. The interesting thing about their objections, all three
Dr.
letters.
Ellman, excuse me for a moment. We have a question. What is it? What was their reasoning for wanting to do that? Were they citing data? Did they have a case? Were they citing specific instances?
That's an excellent question. It's exactly on point. To my mind, all three letters had a terrible deficiency, which is they never took issue with any of the studies that were carefully described and surveyed in the commentary in the draft. I mean, they just didn't. My favorite of the three was NCMEC's that basically said, if you pass this, we don't have anything to do. And obviously that's not a good idea. I mean, I'm paraphrasing, but that was sort of the gist of it, as far as I could tell. That was their principal objection. And, and all of the letters, you said, well, these are bad crimes. You can't do this. And they just sort of ignored all of the data that had been marshaled to show, A, that the registry does not actually reduce reoffending, B, that it doesn't reduce sexual offending in general, C, that it may actually, to the extent we figure out an effect, it may make it worse by thwarting people's ability to re-enter civil society and become productive citizens again. See that there are other things that do help reduce sexual reoffending that don't involve public humiliation and shame and condemnation, but involve helping people to get back on their feet and helping people to develop a social support system, et cetera. And there's, there are programs, not very many, not nearly what they ought to be, but in any event, they just ignored all that. And so the council and the reporter decided that they basically were going to hold firm on this. They made a few very small concessions. And I don't know how much details go, but on this one issue of the registry, so one example of a concession, probably the most important one, was that if you're an organization that works with children or the elderly or the disabled, and you need to do a criminal background check on somebody who you're contemplating hiring, or maybe would even be a volunteer, signed up official volunteer in your services. You can, if a state sets up an appropriate statutory system that creates some state agency that's in charge of this, you can apply to that state agency and ask them, is Joe Smith, we need to do a criminal background check on Joe Smith. And that agency then is able to access the registry information to find out whether Joe Smith is on the registry, and then can tell that, not that they're on the registry, but what offenses they've been convicted of, to the inquiring. But all these provisions, this is an example, the code, the model penal code, it's a felony, class 4 felony, for anybody to violate the confidentiality of the registry and provide information about registrants or who's on it that's not authorized by the code. So, I mean, it's a concession they made, but it was a fairly limited concession. And there were a couple of others like that. The other thing they did that caught my eye was, originally, all these rules about the registry applied across the board to anybody who was currently obliged to register. And they had very few people who were currently obliged to register, even under their very limited version of the registry, no public access. They still had a fairly short list of people who were required to register. And then they said that nobody else is, whether their offense is covered by this code or by some other code. And that was important to me in particular, because I've been particularly interested in possession of child pornography offenses, which are obviously registrable. And those are not covered by this chapter of the Model Penal Code because it's sexual assault and related offenses. And so it doesn't address possession of child pornography. And I am frankly not sure that there was such an offense in the original Model Penal Code altogether. And so there still may not be, because they haven't, I don't think they've, or at least not yet, gone back to deal with what are called public order offenses, which is what I think, if there was such an offense in the Model Penal Code, that's probably where it would be located.
So that would be kind of the safety net or the catch-all for those kinds of crimes.
Yeah, well, it's
the
just
backstop.
things for which there's not an easily identifiable victim necessarily, and it doesn't matter whether you can identify a victim, it's still an offense. It's a public order, they're called public order offenses. And if possession of CP were an offense under the Model Penal Code, that's probably where it would be. And so any event, what they did, that they also did is they said, look, and I remember I had this long discussion with Steve about it, they limited these registry provisions to the offenses that were offenses under this section of the Model Penal Code, and said, we're not speaking to any other offenses. And that had me very concerned, because it might have left offenses like possession of child pornography on the old-fashioned registry, while everybody else is benefiting from these new provisions. But they were concerned about, they said, we haven't studied these other offenses. We can't make the kind of case. They agreed with my instinct, but we don't have that. So when it came back to the membership in May of 2022, this new revised version that had a few small concessions, but not this, I prepared some amendments that I made from the floor, And I discussed them all ahead of time with Steve, who agreed to support them all, which meant that they had a much improved chance of passing. And one of my amendments basically said that the registry provisions applied to any offense that's made registerable by any law, including the other laws other than the ones that the sexual assault provisions.
So anything that was left out, you referenced back to it so that it could.
Yeah, and because what they didn't want to have, they felt I could no longer say it's not a registrable offense because that wasn't in the code. But I said, well, okay, don't say it's not registrable, but at least say the people who have to register under that offense get the benefit of a law enforcement only very limited access registry, and get the benefit, by the way, of a second provision, which I think is almost as important. The second provision basically says that any registrant who is compliant, who does everything they're supposed to do, is off after 10 years. That's it. 10 years is off. And no matter what, they're off after 15 years, no matter what. I mean, if they commit a new registrable offense, then that starts the clock again, but otherwise off. And so that was important too. I mean, I've been fighting a battle in California, not successfully so far, in which possession of child pornography, we did a whole revision of our registry, which was originally lifetime for everyone. One of the only states, along with Florida and South Carolina, that has that. And so that was good. We actually managed to get the legislature to change that, and mostly for the good. But at the last minute, they took possession of child pornography because the woman who happened to be chair of the Appropriations Committee in the House here in the Assembly, in the California Assembly, had a being on it about this. And so at the last minute, it went from being a tier 1 offense, you're off after 10 years, to a tier 3 offense, lifetime. So that's what it is in California, which is ridiculous. And so I was very clued into this particular aspect. And so it now is covered, as is every registrable offense has the benefit of no more than 15, and anybody compliant, no more than 10. And the registry is completely non-public for limited law enforcement use only. Those are really the key things. And so it went back, and then Nick Mick asked for the opportunity to speak to the membership, and I was sort of bracing myself for that. What they said, it was the most ineffective person. I mean, the woman who spoke on behalf of Nick Mick had absolutely no impact at all. She just, again, they just didn't respond to the points. It's really quite remarkable. And so my amendments passed. I had 3 of them. My amendments passed, and the thing was adopted. And in September of 2022, it got its absolute final adoption from the council as it went through. And so it's a done deal now. It's a completely done deal. Steve has this task of, they've put together all the black letter, that's done. He has to revise the commentary now in light of some of the changes and make a final version of that. And Steve is retired from NYU, and I like dealing with him. He's very effective, and he's older than me, and I don't get to do that. Get to deal with really active, exciting people older than me very often. He's 80, I'm 77, any event, so, but he's going to take his time doing this. So I think they won't have a final published version in hard copy with all the commentary till months from now, but it will come, and the content of the black letter and everything really is basically settled. One of the key points that's made in the commentary, and that also was just never responded to by the people who objected to what the ALI was doing, is that the United States is an outlier in the world on this. Nobody else has a public registry and website the way we do. None of the countries that we like to think of ourselves as being peer countries, other Western democracies, none of them have this. Canada doesn't have it. I mean, it's just not something that's done anywhere else. And the reason, I think, at least in a way, I mean, there are a lot of reasons for it. There's different traditions about privacy as well. But I think, the data on it has got to play some role in this. So that's the final outcome of the internal process of the ALI. Now, the next question reasonably is, so what's going to happen? What next? The ALI traditionally does not lobby. It doesn't go to legislatures, and so its view has always been, well, first of all, they're basically oriented toward courts. You don't lobby courts. And most of their work is aimed at judges, how to interpret the law. So it's just not part of their tradition. But they also just, they lay it out. We've worked on this for ages. We figured it out, what makes sense, and here it is. And so, and one of the first letter from the Department of Justice, actually the only letter, they didn't write new letters after they lost that objected to it, said, well, if you do this, we're going to tell state legislatures not to adopt it. Our view is you shouldn't adopt it. That's what they said. And I just got an email from Steve a couple of days ago saying, well, here, this will make your day, that there have now been bills introduced in the Texas and the Tennessee legislatures that basically say no one is allowed to ever refer to the model penal code. And I think one of them, I forget which one, is actually broader and says, we're not paying any attention to anything the ALI says now. And he said that these were introduced, I think in one of them already passed one house of the legislature, not the second, without anybody ever seeking to find out what the ALI's position, why they took the position that they took. So that's not entirely shocking in the sense that I've never thought that the legislature is going to be an early adopter of good reform efforts. I mean, getting the California legislature, which might be about as easy, if you're going to get one legislature in the country to do something sensible, you had a short list of who that might be. It might, you could think of maybe 4 or 5 states. California legislature would be one of them. And I mean, it took enormous effort to get reforms through the California and you heard my sad story about what happened to the child pornography provisions, but the way we got it through was we had endorsements. The basic text was proposed by the California Sex Offender Management Board, which is created by the legislature, which has some law enforcement people on it as well as some other folks. It was endorsed by the Association of District Attorneys of California. It was endorsed by the police, the Association of Police Chiefs, in California. We got one victims group to sign off on it. And then the ACLU, the usual suspects. The ACLU has a big lobbying arm in Sacramento. They worked on it. And then what turned out to be really important is an organization called Equality California, which is an LGBT advocacy group, also took it on as a cause. And so with all that, and then we got a senator from San Francisco who probably had the safest possible Democratic seat in the legislature. He introduced it, and it was sort of a thing for him too. And so he was, and we managed to get it through, and it was a battle, even then, right? So I've never been that hopeful that legislatures would do it. You could hope that they come on board after lots of other reforms have taken place, sort of the way it happened with the decriminalization of consensual heterosexual adult behavior. I mean, legislatures weren't the first to act, but they came on board later. I began to say I didn't think that the legislatures, I wasn't shocked that politicians were not jumping on board on this, right? I mean, this is not generally the issue that you run for the legislature on. I'm going to get rid of the registry. That's not usually regarded as a winning campaign platform. But I was hopeful that courts would pay attention. And we have a little bit of a test of that right now. There's a case that's coming, that is before the Pennsylvania Supreme Court. And I do think actually that some state Supreme Courts are the best venue right now. The federal courts are probably not as welcoming as they might have been at one time. Justice Kennedy was a big loss, actually, when he left. He was getting ready to repudiate what he said, that I'd written that article criticizing. You could see it coming, and then he retired and didn't get to do that. But there've been some victories in some state Supreme Courts that one can't ignore. The most surprising, it might be the South Carolina Supreme Court. The Alaska and the South Carolina Supreme Court both said similar things, although they based their decisions on different legal doctrines. But the bottom line in both of them was, you can't just keep somebody on the registry forever without giving them a chance to show that they don't really pose much of a risk. Which was, of course, in South Carolina was like the old California law, everybody's on for life. Alaska, the plaintiff was a guy who was on for life. Everybody isn't, but he was, and he said, I'm not. Both courts, the Alaska Supreme Court based it on a provision in the Alaska Constitution that protects privacy. That Alaska has its own privacy provision in its constitution. California does as well, so that's something I'm hoping to be able to work from. The South Carolina Supreme Court based it on a general doctrine of called substantive due process, and that's a whole class in constitutional law that I don't really have time, and this is probably not the most apt venue to pursue that. But basically, it triggered some scrutiny. Once the South Carolina Supreme Court, using that doctrine, was able to say, well, we don't have to just take the legislature at its word here. We can ask whether or not the underlying facts support what it said. That's really the key. You have to get over the hump of automatic deference to the legislature. You've got to find a legal doctrine that allows the court to say, well, we can examine whether the factual underpinning that's assumed by this legislation actually is true. It actually makes sense. You've got to get a legal doctrine that allows you to do that. You can't do it for anything the legislature enacts. And substantive due process is that sort of doctrine. Well, in Pennsylvania now, there's the Pennsylvania Supreme Court in earlier years had held that one's reputation is a liberty interest protected by the Pennsylvania Constitution. And what that means is that it allows the Pennsylvania Supreme Court to look past, say, well, this public registry is terribly damaging to the reputation of those who are put on it. And the state to do this harm to their reputation, because that's protected under the Pennsylvania Constitution as an interest, an individual personal liberty interest, we can ask whether or not there's a good basis for that there is some basis. So that's basically the claim that is before the Pennsylvania Supreme Court. And I wrote a brief in that case. It's called an amicus brief. I'm not the lawyer for the plaintiff. A friend of mine who's the appellate public defender in Philadelphia is in charge of the case. But I did a brief for a group of 16 scholars in the area from all fields: economics, sociology, law, a whole bunch of criminal justice scholars who all had written on this subject. And Aaron, in the case as it was brought, had some experts, some really key experts testified in his behalf. And so basically, we're saying there's no underpinning there. Well, in the amicus brief, I was able to say, we all think this is right, that this view of the scientific evidence that the registry has no useful impact, that it can actually reduce rather than enhance public safety, et cetera, et cetera. All those things, we can not only say we think it's right, so does the American Law Institute, and refer to this commentary, and can also say, and the American Law Institute, as well as these other studies that we could reference, have concluded that nobody else in the world does this because they also think this is right. And so this is actually a very peculiar position that's being taken by the state of Pennsylvania. So that's the case. I finished that, Aaron did his main brief, and I did the amicus brief a few weeks ago. And there's a reply that the state of Pennsylvania, of course, gets the opportunity to file, and then it'll be argued. Aaron thinks maybe in May they'll have an argument before the Pennsylvania Supreme Court, and then we wait for a decision. But I think that the model penal code, as it's been revised, is helpful to us in that case. And so I think probably that's going to be the most likely helpful impact that what the ALI has done. You've got to be in a state that has laws or Supreme Court that will entertain the claim seriously. But that's not every state. But say I was astonished that what the South Carolina Supreme Court did, and at the last meeting of the American Law Institute, I happened to be sitting at their dinner next to a lawyer from South Carolina, and so I asked him about it. How do these people get appointed to who are these people on the South Carolina Supreme Court? Anyway, it was interesting. So anyway, that's it. I have nothing more to say, but I'm happy to respond to questions.
So does the model penal code address civil commitment?
No, because civil commitment is, quote, civil. It's not a penal statute, right? I mean,
It's like civil forfeiture in
seems
the
like a
same way.
penal
Okay,
statute
I
for
understand.
everybody who's committed, but that's, yeah, it does not. That's a whole other area. I have a good friend I've worked with in this, who's, for him, that's been the main focus of his efforts. There's an organization called the Sex Offense Policy and Litigation Center at Mitchell Hamline Law School. They have a website. You might find it, you probably would find it of interest to go to their website. Solperk, some of you may have seen it. I'm on the steering committee there, but it's, the director of that is Eric Janus. And he got into this whole issue largely through the civil commitment aspect and has been instrumental in some cases. Boy, he won a great victory, and then it got overturned in the appeals court, but he's still battling it. Minnesota, where he is, had a particularly awful one. California had a pretty awful one too, although that's improved after some lawsuits. I won't exactly say it's just dandy, hardly, but it's not quite as awful as it had been. But still pretty bad. Yeah, that's, that's only one version of the most important one of keeping people effectively incarcerated after they've served their sentence. There's another version of that that's happened in places like New York that is really outrageous, which is they have residency restrictions that prohibit people from living in various places. And then it turns out that somebody is in prison and can't show at the end of their sentence, can't show that they've got a place to live when they're released that's compliant with the residency restrictions. And so then they don't let them out. They've served their sentence, but they don't let them out. It's really outrageous. And so there've been challenges to that too. And I think one of those was successful. Yeah, I mean, there's a lot of aspects to this whole world that are very indefensible in my mind, but.
So given what you know about a place like Arizona, where do you think, what do you think is our low-hanging fruit, or what do you think is the easiest issue to tackle, or how do we make progress?
I haven't kept in touch very much. I mean, I've been gone about 10 years now. There used to be some good justices on the Arizona Supreme Court that I knew personally. Andy Hurwitz, but then Obama put him on the federal court. Yeah, I mean, any event, then it got sort of made over by Governor Ducey. And then they enlarged the court from 5 to 7, which gave him 2 more appointments. So I haven't kept track of who's been appointed and what they're like and whether they're reachable on issues like this. But, I guess my instinct would not be very optimistic. But on the other hand, I will say there's one interesting thread on this to point out, which is that a bunch of the libertarian leaning organizations that you might, one normally regards as unfriendly, certainly unfriendly to most liberal programs, have taken on criminal justice reform as an issue they care about. You may recall that was an issue that actually the Trump administration purported to care about. And I don't know that President Trump personally had much passion or interest in it. Jared Kushner did, his son-in-law, because his father-in-law had been in prison and that sort of experience does tend to reach people. But it was a libertarian ordinance, and there was a suit brought here in California recently by the Pacific Legal Foundation that challenged an aspect of the federal SORNA regulations, and won. Then the Pacific Legal Foundation is certainly a very conservative organization, libertarian organization. Reason, there's a magazine called Reason, which is a libertarian magazine that's had some very critical articles that they've published about the registry. So there was at one point, and I'm blocking on his name now, which he was put on the Arizona Supreme Court shortly before I left town. Blocking on his name. Who was
Montgomery?
Sorry?
Is it Bill Montgomery?
No, not Bill Montgomery, who, if he's who I think he is, I wouldn't be so hopeful about. But there was another guy, well, it doesn't matter. Any event, he was a conservative appointee, but he was clearly a libertarian in his heart. And he participated in a reform conference that the Koch brothers had paid for at Arizona State at the law school. And I was an attendee at that conference, and there was a very critical assessment of registry rules that was prepared for that I did some. I participated a little bit, and I was just kind of a responder, certainly not the main mover. Would have been different if I had been, but any event, all I'm saying is sometimes people can surprise you on this. If they have a libertarian streak, even if they're not otherwise friendly to progressive or reform on this issue. So
understood. We have another question. When was the last time the Supreme Court ruled that the registry itself is not punitive? Can you kind of unpack that distinction between punitive and administrative, and kind of what that means and how that happened?
Well, that distinction was drawn in the those two cases, Smith v. Doe, and the one that followed close upon it the following year, both authored by Justice Kennedy, who, as I say, I think was getting ready to change his mind. But the figuring out whether something is punitive or not is a technical, traditionally regarded, is governed by rules that seem sort of technical. I mean, you say to somebody who's suffering under the registry, well, it's not punitive, and they have a lot of trouble comprehending that because it sure feels like punishment to them. But how it feels to them is not the legal test of whether it's punishment. There's a more complicated legal test. And what happens, of course, is there's all sorts of constitutional rules that are triggered by the imposition of punishment, things you can't do if it's punishment. And so, the one that gets a lot of attention is the ex post facto clause, that is to say, making people register for a crime that they were convicted of before the registration obligation was created, which if that was punitive, you couldn't do it because it's civil. The courts have usually held that you can. There's been some change by some courts in that, some important courts. So Miriam Ackerman, who's an ACLU lawyer in Michigan, partnered with the legal clinic at the University of Michigan Law School and won this great victory in federal court in the Sixth Circuit Court of Appeals, which is the federal court of appeals that covers Michigan. They held the Michigan registry was punitive. Now, the reason that they could do that, even though the Supreme Court had held it was not, is the argument, and it was a pretty persuasive argument, is that, look, with the registry that the Supreme Court saw wasn't the registry that's in place today. That registry didn't have that much to it. There weren't very many things that happened to you if you were on it. But now there's all these things that are triggered by being on the registry, burdens. And when you put the whole package of burdens together, the residency restrictions, the fact that you have to register in Michigan multiple times a year, that there are all these traps for the unwary, that you might mistakenly, even though you were in good faith trying to be compliant, it was pretty easy to run afoul of this or that rule in registering, et cetera, et cetera. They put that whole package together and said, this is a punitive package. And they called the second generation registry. And the Sixth Circuit Court of Appeals, in an opinion written by a very conservative judge, famously conservative on criminal justice matters, held that it was punitive and threw out a bunch of the Michigan registry.
Wow.
That's the case that led me to think that Justice Kennedy was thinking about, well, actually, it was another case in which he made some comments where they threw out a North Carolina rule involving the guy who bragged on Facebook about getting off of his traffic offense, and he was on the registry and he violated his registry rules by going on Facebook, even though what he did was totally innocent, and that violated North Carolina law, and the Supreme Court held that violated the First Amendment to say he couldn't go on Facebook. And so they threw out his conviction.
Packingham?
Packingham is the name of the case. And the key thing in that, Kennedy wrote the opinion for the court. And he said, well, I'm at one point, basically, he said, I'm paraphrasing, but the gist of what he said was, well, we can decide this on the First Amendment. And so that's all I'm really speaking to. In this case, we're not addressing all the troublesome restrictions that are being imposed on people who have fully served their sentence. And you could tell that
he's like foundation, set some groundwork.
As people had, and he had some, because he's really a good guy, actually. I mean, he was on this issue, he was critical.
I have a follow-up. Go ahead. We appreciate the thorough explanation. The question was a little rhetorical. In Arizona, the registry has been amended a few times and had some different things added to it. So we've been working on a year to prep a federal case to challenge the registry that takes into account all the new amendments and everything. Some people have to register 4 times a year in Arizona. So if you have more than one house, you're classified the same as if you're homeless, which triggers the every 90 days you have to check in and register in person. Would that interest you in possibly following up with to kind of get your opinion on and possibly work with you in maybe an expert testimony kind of situation or something?
Well, what you want in expert testimony is not, my role in this is as a kind of a translator of social science evidence for judges and lawyers. I do have a background in social science, and I've done some work, but I've not done any empirical work in this area. I did it in my old field of family law. But because I'm conversant in the methodology, I understand the work that's been done by social scientists, and I know how to explain it to judges and lawyers. So that's the amicus briefs I've written, that's really kind of their role. But in terms of putting a case together that is a successful challenge, the model for a successful challenge of that kind, especially if you're in federal court, that you want is the victory that Miriam Ackerman succeeded with in the Sixth Circuit case I started to describe in Michigan. Now, she's an ACLU lawyer. She's not a private lawyer, and she's very busy, but she cares about these issues. And I think that in terms of getting really knowledgeable advice on how to put your case together and how to proceed, she and her co-counsel in that case, Paul Reingold, who is, I think may now be retired or emeritus at the University of Michigan Law School, really would be my first go-to. And one of the key things that they did is they did have expert testimony. And that was also true in this Pennsylvania case, but the expert testimony are social scientists. So like in the Pennsylvania case, the experts that I was backing up were Carl Hansen, who's done all the studies that you probably are aware of about, and J.J. Prescott, who's an economist at the University of Michigan Law School, but he's an economist. And he's done studies on how the registry isn't very effective at reducing reoffense rates and can sometimes. And so you need experts like that who've done those studies. That's what, it's a big undertaking. It's a very expensive and extremely time-consuming undertaking.
Oh, he knows. He's been on it for a year with a whole team of attorneys. He's put a lot of resources behind this.
I mean, I would be.
Paul Dubling is part of it. He's on the team.
Who's on the team?
Paul Dubling.
Yes, I've spoken to Paul Dubling and I know who he is. He's a NARSL. He does often work with NARSL. And I don't know him well, but I know of him and I've talked to him once. Are there local people in Arizona who's, because Paul's in North Carolina? Who are the Arizona?
Overwhelming, no, not a lot of.
Yeah, because that's really what you need somebody. You have to have some local counsel. You can't file it. I mean, they could just be a figurehead and someone else does all the work.
Yeah, we have that much. Yeah. So we don't want to take up too much more of your time. Does anybody have a final question that they would like to ask of Dr. Ellman? And you have been so generous with your time this evening. We really appreciate you.
Well, I'm really pleased to do it. It took a long time to set it up because I just had, and then it turns out I teach in San Francisco on Thursdays. I normally can't even do Thursdays, but this is spring break week. So there was class this week. So any event, I'm glad it, I have lots of memories of Arizona, and I still have a son who lives there. So this part of my heart goes out, especially to the folks there who are suffering under this. So, okay, it's been a pleasure. Bye-bye.
It has. Thank you so much. Arizonans for Rational Sex Offense Laws is the only nonprofit in Arizona providing education, advocacy, and support for those living on the registry. Donations can be made from our homepage, azrsol.org. Your donations will help us continue to fight for the basic rights of those living on the registry. We believe that denying any group of citizens their civil, constitutional, or human rights threatens the essential liberties of us all.